Okay, so we're covering the last section of Chapter 5-3, Civil Procedure. We are just going to be talking about the process of the civil court case. And we're going to do this because we are then going to view a film, and I want you to be able to identify and see the different parts of the civil court case. So once we have established that there is a wrong, there is a breach of duty, a violation of duty, and there is an actual tort case, then we go to court, and this is the civil procedure. Okay? So the essential question is, what are the legal remedies that are available to a tort victim? So when a person has been wronged and we have a plaintiff, okay, what are the remedies? What are the things that we can do to make it right for that person? There are two. There are two ways that we can make it right. So if we are talking about a case of, I'm sorry, arson, okay? Or if we are talking about a case of false imprisonment, how about false imprisonment? Okay, so where was I? Okay, so we have a tort of defamation of character. Okay, defamation of character, when somebody talks, says negative things that defame and injure the reputation of a person. Okay, what are the ways that we could fix that? Well, if we would need evidence to prove that that occurred, but what are the ways? The remedies is what we're talking about. Remedies to a tort case. How do we fix it? Okay, do we put that person in jail? The person who harmed the reputation of another person? Go to court, and then what? What are we looking for? What are we looking for? We're seeking money, okay, in a court case, in a tort case. Okay, so our two legal remedies that we have are injunction, which is a court order to stop doing something or to start doing something. And then we have, we have damages, okay? Okay, so here's your verdict. Okay, the owner of a dry cleaning store lived next door to this Erdley guy who ran a competing dry cleaning store in the same town. They quarreled frequently and became enemies. One summer night, Erdley composed, printed, and secretly posted a flyer all around town accusing Horsley of dealing with untrue and defamatory things. Okay, so this Erdley guy defamed Horsley's character. Several witnesses saw him posting the flyers. Okay, what would Horsley, if he sued this Erdley guy, what would he be seeking? Because they both are in the dry cleaning business. If people believe the flyers that were posted, okay, what would that Horsley guy be losing? Money, okay? He'd be losing business, okay? So then what could he potentially sue, okay? Because Horsley wasn't physically injured. He didn't break a leg or an arm, okay? None of his buildings were shattered or broken. Nothing was broken, but his reputation was damaged. So if he sued this Erdley guy, what would he be suing for? Money, okay? He's seeking damages and an injunction to stop printing the flyers. Okay, so what are the damages that he could collect? Remembering, damages are money that is awarded by the court, okay, to the person who's been injured, and they've suffered the loss, okay? So it's all about money. And in tort law, we're looking for people with deep pockets. We're not searching for, generally speaking, you're not looking for, $100. You're looking for thousands or hundreds of thousands, okay, millions. The other is an injunction, a court order for a person to do or to not do a personal thing, a particular thing. Okay, these are issued by the court, by the local city, state, or local court, and they are official notices. This one is talking about a criminal street gang, and it's a notice to have them not. It's an injunction that will not allow them to gather on certain premises. Um, but that is what an injunction is. Okay, so if the injunction is issued but there is no damages awarded, then they just tell the person to stop doing it, but there's no money that's exchanging hands. Okay? And so again, the remedies available in a civil suit: injunction and damages. You need to know these. Okay? All right. There are two kinds of damages. There are compensatory damages, which are for your actual damages, and your punitive damages. Compensatory is meant to return the person to the place where they were before the incident occurred. Okay, so if we were talking about the case where the guy's reputation was slandered, okay, compensatory damages might pay for him to have an ad that runs on TV and some signs posted that say that the flyers were untrue and he really is a good guy, a good business person, or something like that. Okay, to return him to the state that he was before. The idea of compensatory damage is not to get rich. It's not, I'm going to sue you for a couple $1,000,000. Okay, unless he lost a couple $1,000,000, he would not be returning to the state that he was before. It's just to bring him back to the place where he was before. That's the idea of compensatory damage. Okay? If I ruin your sweatshirt somehow in my negligence, I don't have to buy you a new wardrobe. I don't have to give you $100,000. All I have to do is possibly replace your sweatshirt, correct? Okay, that's compensatory. Punitive is meant to punish the person. So when we are talking about intentional torts, and this guy intentionally defamed the character of this other dry cleaner, a punitive damage would be issued to punish him, okay, to make sure that he doesn't do it again. So we might issue punitive damages in the hundreds of thousands of dollars, okay, or make him, hit him where it hurts in his wallet. Okay, so if I was going to be issued a punitive damage after ruining your sweatshirt, and they wanted to make sure that I never ruin a sweatshirt again in the same way, I might have to buy you, I might have to give you $10,000 or something. That would be a punitive damage to me. Okay, compensatory is more common. That's just returning you to the place where you were before the incident occurred. Okay, but punitive is to punish you, is to make you hurt. Okay? And then further along the way, we'll talk about pain and suffering, which, okay, so compensatory, it will not take you from this beat-up car to this fancy pants car. Okay, that is not the purpose of compensatory damage. It's just to take you to this car with the scratch on it to the same car with the scratch buffed out. Okay, it's just to right the wrong. It's not to get you rich. Okay, so the sum of the injured parties, lost wages, doctor's fees, and then a monetary amount to compensate for pain and suffering. Okay, now this is where we get into that gray area of Nick, his sweatshirt has been ruined. Instead of just getting a new sweatshirt and being okay with it, he's going to say that his whole life has been changed. He can't sleep at night. He can't eat. He started wetting the bed. He doesn't know what to do with his life. He's got to go to therapy, and he's got to go medications, and his whole world is ruined because of the sweatshirt. And Miss Robel, she ruined it. And so she owes me $2.4 billion to fix what's wrong. Okay? Now, that's a little far-fetched. But we do have pain and suffering people started to sue for this pain and suffering, which, who can put a limit? Who can say how much your pain and your suffering is worth? I don't know. I mean, they do a mathematical algorithm, a calculus, if you will, to put value on human life and on pain and suffering. But, if something happened to someone that you love, who is there to say it's worth X amount of dollars? Okay, but that's what this whole legal system, this tort law, is about. Putting a dollar sign on on pain and suffering. So we have severely restricted tort reform because people were starting to be fraudulent and use some of these lawsuits to get rich. Okay, so Nick doesn't really care about the sweatshirt, but he sees an opportunity to make a couple $100,000 on his pain and suffering, and so he's really going to go for it, All right, not real, just for pretend. Okay, it is determined by the trier of fact in each case. All right, that's compensatory. Punitive, again, this is your punishment. There's a girl in timeout. Okay, punitive, the word means intended as punishment. Okay, and then this image, I want you to tell me, what does this image mean in relation to punitive damages? Take a minute, look at it, and tell me what you think it means. Rob, you can do this too. What do you think this image means in relation to punitive damages? Take a minute. Okay, what does this image mean in relation to punitive damages? Who wants to answer? So when I said, are you ready to tell me, you should have said no. Okay, I will tell you, Rob. You can. Okay, go. Yes. Yes. Okay, so the money might be extra, but what it's saying is that it's more, the punitive damages would be more than what you, the actual damage was that was injured, okay, or was caused. But what this is saying is that punitive damages balance the scale, okay? So they make it even and makes it, it's kind of justice here, okay, is what this is. So it gives justice to people who've been injured. Now, can you right or wrong, you have a scratched car, you fix the scratches on your car, you have ultimately returned that vehicle back to the way it was. Okay, now, it was annoying, it was a pain in the butt to get it done, you had to go and whatever and take a day off of work. And so if they calculate those things together and they pay you, money to repair the car and pay you for your day off, okay, then you're even. You're done. Okay, now, if you have lost a loved one, how do you ever kind of come back to that place? And that's where we get into, if you lost your arm or your eye or your ability to see, your ability to walk, if you lost your ability to make money for your family. Okay, so there's these big, huge things that are beyond the small role of tort law, and so that's where we get into these, big punitive damage cases. So, okay. So, and what's your verdict? Horsley could recover both compensatory damages for the provable loss of business and punitive damages, okay, to punish that other guy, Erdley, for his conduct. Okay, so he can, if he can prove that he lost business, that people said, no, I'm not going to your dry cleaning business anymore. I'm now going to go to the Erdley dry cleaners because I heard you're a scammer. Okay, if he can prove that, then he can get compensatory damages and punitive damages. All right, last couple slides here. Steps in a civil procedure. I have these broken down into 4. That's in your book. That's how it's categorized. Okay, we have a judge and jury, a judge or jury, I should say. In a criminal case, as in a civil case, a jury is an option. Okay, so if you opt to have a jury, then there is a jury selection process, which we'll talk about in a minute. It is the defendant's choice. Yes, it is the defendant's choice. Sorry about that. In opening statements and testimony, we'll talk about that in a minute. We have closing arguments, instruction to jury, and then jury deliberation and verdict. Okay, so in judge versus jury, the jury is selected in a process called voir dire. That's how you say that. We're actually going to talk a little bit more about this. It's kind of one of my It's one of the things that I really enjoy. If we have enough time, we're going to go there. And then there's a movie that really, really nails it. Okay, it gives you an inside look at the voir dire process and everything that goes into this civil litigation. I think it's kind of cool. But anyway, and then the right to a trial is provided by the Seventh Amendment, trial by jury. You do not have to have a jury. Okay, what is the benefit though? What are jury members are comprised of? Random citizens. Okay, are you just saying words you see in your book? They do issue a verdict, but they're comprised. The jury is made up of random citizens who are not skilled at law. They're only looking at the issues of fact. Okay, the judge decides the issues of law, and so therefore, sometimes they're hoping defendants are hoping to get a sympathy vote. Okay, from the jury. Okay, because jurors, after all, are just people. Opening statement, a brief outline of what's going to be proven. Both sides make an opening statement. Okay, the plaintiff side comes out and says, I'm going to tell you why the defendant caused the accident, blah, 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 and why he deserves to, pay for the pain and suffering of this person, blah, 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 blah. And then the other side, the defendant's attorney will come out and say, I will tell you why the defendant is not responsible for what happened to so-and-so, and here are the reasons why. This is what I'm going to prove. Both sides lay out their outline. Whether or not they do it, that remains to be seen. Okay, then we have evidence. This is where our testimony comes in. Our written documents, charts, records, photographs, video, degree locations and mappings and physical evidence and blood samples and whatever, water samples and all kinds of evidence. And then we have, okay, wait a minute. Okay, here's our vocabulary. Testimony, these are statements made by witnesses, made by witnesses under oath. Okay, a witness is someone who has personal knowledge of the fact. They've either seen it, heard it, lived it, experienced it, whatever. They have some inside knowledge. Okay, an expert witness has important factual knowledge, but they weren't there. Okay, so I might be an expert education witness. I am not in that classroom in Tennessee, but I know about classrooms. So I fly to Tennessee and I explain what I think might have happened based on my factual knowledge. Okay? We could have expert witnesses in 100 different fields. Okay? Expert witnesses about, airlines and vehicles and road, management and all kinds, just anything you can think of. An expert witness, they don't have any specific information about the plaintiff or the defendant, but they do have information about the topic at hand. Okay, and then the last is a subpoena, a written order to appear in court. Okay, if you get a subpoena, you must appear. Once you get up there, you must testify. I'm sorry? Or you run to Mexico, I suppose. Once you've been subpoenaed, you must testify, otherwise you are in contempt of court, and contempt of court in either civil or criminal can result in you being placed into jail. Okay, it is punishable by jail time. So then you are, if you are testifying, you must testify under oath, therefore you must tell the truth, and yada, 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 it's a whole thing. Okay? So, here is our what's your verdict? Okay, when their cars collided at the intersection, Claxon and DeLucia caused the accident. Claxon claimed that DeLucia caused the accident by failing to stop for his stop sign. Okay, DeLucia claimed that he had stopped and then moved through the intersection. He said he had not yet reached 5 miles per hour when Claxon ran his stop sign and slammed into him. So they both have these conflicting cases. They have two witnesses, but both witnesses saw different things. Now, I will say this. With eyewitness testimony, I would have sworn to you, I would have given you $1,000 that said, my son at his wrestling match, that he shot in during the third period, that he shot in, and that the other kid spun around and got his too. Okay, and that's how I thought that went down. When I reviewed the video, I was dead wrong. I would have bet so much money that what I saw happen. But when I watched the tape, it's crazy because it's not what happened. And my husband and I and my family members, we all watched it and we were going, wait a minute, that's not that's not what happened. That can't be what happened. We thought it was this other thing. Anyway, so eyewitness testimony is not always as accurate as people believe. But so we have two eyewitness testimonies. They have conflicting stories. How can the court determine what really happened here? What would be the option? Okay, we have this guy who says this thing. This guy is he said, or she said, or something. Okay, our witnesses can't agree. What? What would we be left to do? Okay, if our options are testimony, which we have, okay, written documents, charts, records, photographs, and debris in locations and physical evidence. Okay, what would our other option be? We have our testimony from our witnesses. How about expert witnesses? If we have expert witnesses who can show, okay, from based on the speeds, the skid marks, the location of the glass, they actually measure, in a crash, they can measure where the glass shatters out in the directory that the glass shatters out, and where the car ends up. They can recreate the accident, and then they use all these measurements to do it digitally, so you can actually see the accident as it happened. Yes.
Do you have cameras there? Like in the situation?
In this particular situation, no, there were no cameras. So they're going to have to rely on the forensic knowledge, okay, on the measurements and all of the they have photographs of things. So they, and if you've ever seen in law enforcement, or if you remember from that camp that we did, when you take a photograph in law enforcement, okay, an evidence photo, there's always a scale. There's always a ruler that shows you so that you can see to scale, where it is, where things are located and how far they are and distance and things like that. So it's all very scientific. Everything is measurements. It's all very exact. There's no like, over there by the trash can, like, right about a little smidgen to the left. Okay, it's not like that. It's very, very specific. So we would have to get expert witnesses and rely on all of the records and the facts of the case here. Okay. Closing argument, that's the last thing we do. Each side gives a closing, which summarizes the case and tries to persuade the judge. You want to be likable. You want to get the judge or the jury to buy into you at this closing argument. You don't want to be a jerk, but you do want to make a powerful statement about your client or about the defendant, with whichever way you're going. And you want to try and get them to see your side. Okay. Then the judge will give instructions to the jury. And if we have time to watch the movie, you'll see the instructions to the jury. They say, do not think about what a nice person this the defendant looks like. All right. You must decide the issue of fact here, which is, did the defamation of character cause this guy to lose his business? Or, did the guy really, if he ran the stop sign, is that what caused the accident? You're figuring out issues of fact, and then you're deciding, based on that, what the verdict should be. Okay? And then the deliberation, they deliberate in secret, they sit, they talk. Have you seen 12 Angry Men? The movie? Oh, really? What are y'all doing? Or read the book? Okay, so they deliberate and decide in secret. They discuss all the different parts of the evidence. If they can decide by a preponderance of the evidence that one side has more weight than the other, we talked about preponderance of the evidence yesterday. One side has more weight than the other. It does not have to be unanimous. Okay, the jury will say, 6 of us say that the defendant is guilty and he should pay, and those 3 over there, juries aren't always 12, by the way. But those 3 over there, they don't agree, but tough beans. Okay, more of us says that the defendant is guilty. Okay, the judge renders the verdict. The judge renders the judgment after the jury issues the verdict, and then the money is decided, the amount, if any, or the injunction is issued. Okay, so this is our civil trial procedure. Now, I want you to do this follow-up assignment. You're going to go to the link below, which is actually in Schoology, and you're going to read the case of hot coffee. Okay? It is, rather than read, I should say, you're skimming it. It is the case that I talked about yesterday. The reason why McDonald's has caution hot coffee on the lid of its cups. Okay? This is the case that caused that. 1992. Okay, they settled. But this woman was awarded 2.6 million for pain and suffering after her hot coffee spilled on her legs. Okay, so this is why. But this is a really good example of a negligence case. There's a lot of terminology that you will hear and recognize or see and recognize in this. So I want you to skim through it, identify some terminology that you recognize. Then you're going to list the elements of the tort as you see them. So with the duty of care, with the breach of duty, with the injury, and was it foreseeable, okay? And you'll see it. It's pretty much spelled out for you here. And then you're going to write me a summary. You're going to summarize what happened in your own words and explain what you think about it. If you think it's a joke, tell me why. And use vocab. I want vocab terms from chapter 5 in here, okay? This is a Collins writing 4, so we will be reading and then switching off. You guys will be editing your own things. You can handwrite it. I would recommend that you type it. It's just going to be easier to edit that way. Save your work, submit it on Schoology, and also print it. I want a printed copy first, and then I want the Schoology version also submitted. So you're going to work on this. You have just a little bit of time today to get started reading the article, and then you'll have tomorrow to work on this. We will review a bit. Test will be Friday. I've had to slide that back. So your test, we're looking at Friday. We'll review. Wait, tomorrow's Wednesday. Okay, so yeah, you have time. So we'll be doing this, and then you still have your questions that are due on Wednesday too. Okay, so quite a bit, but I think you got it. The link again is on here. The case is called Hot Coffee, and that is civil trial procedure. You should see the everything as you're going through this. It should ring a bunch of bells about what we've just covered. Okay, and that concludes chapter 5-3, civil trial procedure.